I'm glad you're here tonight. My guess is that estate planning has been on your plate for way too long, but it's felt complicated, expensive. Well, tonight, at the end of this webinar, you'll walk away with a lot more clarity and you'll understand the 4 steps you need to take to create your living trust. Hi, I'm Mirtha Chang. I am a certified estate planner with the National Institute of Certified Estate Planners. I'm also author of Estate Planning Decoded, and I have a YouTube channel where I break down estate planning concepts. A lot of you probably met me through my YouTube channel, so I'm excited that tonight I get to prove to you that I'm a real person, not an AI talking head. In the last 5 years, I lost my father and my mother-in-law. So this topic is not just professional to me, it's also personal. I am not an attorney. I do not draft legal documents, but I will show you a modern online estate planning platform that creates attorney quality documents without the $3,000 to $5,000 price tag. Okay, we will start with the 3 threats to your legacy, because then you'll appreciate what your living trust needs to protect you from. Next, we'll go over the 4 steps to create a living trust. And then you'll have a chance to consider if working with an estate plan partner like myself can help you get to the finish line quicker and more affordably. I'll make sure to have time for Q&A. All right, let's get started. Many of us spend most of our lives building this legacy, a beautiful cake to hand over to our children, our siblings, our beneficiaries, not realizing that they're unwanted guests waiting with fork in hand to take bites of our cake. If we don't plan well, by the time it gets to our children, there may be a big chunk missing. By the time it gets to the grandchildren, there may only be a slice left, or worse, just crumbs. Okay? In this webinar, I want to show you what you can do so that your cake, your legacy, remains as intact, as whole as possible. Who is trying to take big bites of your cake? That's the 3 threats we will go through. Let me start with the story of Jane Mansfield. She was a very popular actress who died in a car accident without an estate plan. Well, she was only 34 years old. The courts immediately took over. Her 4 children had different fathers, so they were split up to their respective dad, even though her friends believed that she would have wanted her mother to raise the 4 children together. But when you don't have a plan, then the court exercises their plan. Her house and all her assets were frozen, so her kids couldn't even get back to their homes. Even small things were locked down. Her daughter wanted this charm bracelet and was denied. It was later sold by the estate. It took 10 years for probate to wrap up. A little bit of her assets went to pay off her debts, but the rest went to probate courts, appraisal, attorney fees, so that her children ended up with nothing. Heartbreaking stories like this don't just happen to celebrities. This recent Forbes article talks about how many families don't realize how draining probate can be. Not only is it an emotional toll, but it takes 20 months. That's almost 2 years to wrap up. All that time, your assets are frozen. and it's expensive. The average, the data shows, is 3 to 7% of your estate. So let's say your estate is a nice round number, $1 million. And let's say your probate went really smoothly, no surprises, no family drama. And so your probate costs the low end of it, 3%. But 3% of $1 million is still $30,000. That's money that could go to your spouse retirement or the grandchildren for their tuition, not to the courts. So that's threat number one, okay? The delay, stress, and cost of probate. Threat number two is family fracture. Many of us know of families that were broken apart after an inheritance, and we shake our heads saying, "Wow, that's too bad. That's sad." But that could happen to our family if we don't understand the sources of family fracture. Okay, first is probate. Probate is not just expensive and draining and stressful, it cracks families. So for sure, it's because of the delays, the fees, assets are frozen. Also, it doesn't help that outsiders, start butting in because probate is public. Former partners, wives, spouses, relatives start whispering things like, "That doesn't seem fair," or "Oh, you took care of your mom all that time," or "Oh, if it were me, I would, fight it out." Did someone say something? So sure, for sure, all those things are very stressful and can put a family on edge. It doesn't help that the courts deliver information and numbers very coldly, not like a trust where you may have a trustee, an uncle perhaps, sharing the information in mom's living room. Probably it's a different vibe. But with probate, it's very stressful, expensive. That would put any family on edge. But what really causes family disputes in probate is that probate provides a ready-made venue for disputes. The judge is already there. The system for filing complaints is already built in. Attorneys are lined up. So all it takes is one, disagreement, a disgruntled family member, and it just escalates because there's already a venue there for disputes and fights. Another source of family fracture is the family home. Do not treat it as just another asset. It's emotional. It's Christmas mornings. It's, baking with mom in her kitchen. It's not just brick and mortar. The family home is also unequal. Maybe one kid has been living in there, taking care of mom, or maybe another kid has been doing all the repairs out of, her own pocket, and it's illiquid. You can't just slice up a house into three. One of my clients offered to buy out the other siblings because he had an emotional attachment to his parents' home. But one sibling preferred that the house be put on the market to see how, much more it would fetch. So it caused a lot of tension. And when it was all over, he said, yeah, the siblings swore that they still love each other, but that relaxed, unguarded vibe, that closeness is just not there anymore. So the family home, pay special attention to it. Another cause of dispute for family fracture is surprises. That's not what mom said or dad told me that, or last minute changes that no one understand, hidden accounts, unexpected debts, unequal gifts without explanation. It's not that unequal gifts are categorically bad. This happened in my own family. When my father passed away, there are five of us, me and four other siblings. When my father passed away, we found out that he actually wrote a brand new will after sharing with us a prior will that he had written. He even had us all, sign it to affirm that we did look at it. But we found out that he wrote a brand new will. And we were all surprised, and it would have caused a lot of resentment because everything went to my older brother, until it was explained to us that because we were all abroad and my brother was the only one who lived in the same country as my dad thought it would be a lot easier for my brother to handle the affairs and to liquidate the assets before it's distributed. So it's not that unequal gifts or new changes are bad. It's just when it's not communicated and it's a surprise. Surprises should be reserved for birthdays, not for a time finding out things in a time of grief. So that's your second threat, the family fracture, which to me is actually the saddest and costliest threat to our legacy. What's threat number 3? So 1 is probate, right? 2 is family fracture. What do you think threat number 3 is? Can you guess? When I ask people this, a lot of times they say it's taxes, death taxes. People are deathly afraid of death taxes, no pun intended. So let's go into these taxes that is scaring everybody off, okay? What are the death taxes in America? First is the estate tax. That's the tax on the deceased person, the estate. Of course, he's not around to sign a check, so this tax is taken out of the estate. That's why it's called the estate tax. And it's very steep. It's 40%. That's almost half. Fortunately, the federal government seems to be only after the ultra rich, the big whales. If your assets are less than $15 million, then you can ignore this at the federal level. But every tax has a federal level and a state level. If you are unlucky enough to live in one of these states that I'm going to list out here in alphabetically so you can look up your state, you want to know what the estate tax exemption is for that state. The ones I highlighted, the yellow and orange, have estate tax exemption of 3 million or under. But the others have 3 million or more. So if you live in these highlighted states and your assets are above 3 million, then you will be imposed an estate tax. But that's just 5 states, out of 50 states in the US. That's just 10% of the states, which means 90% of the states, you either don't have a state estate tax. If like Florida, Texas, that's not in this list, you don't have a state level estate tax, or the exemption is so high. For example, Connecticut, it's 15 million. It mirrors the federal. District of Columbia, 5 million, that you pretty much may not need to worry about it. So that's the first death tax, estate tax. The second tax is called the inheritance tax. This tax is imposed on the person receiving the inheritance. The US government does not charge any inheritance tax. I was shocked when I learned this. It means if I inherit $10 million from a billionaire uncle somewhere, I can dream, right? I will pay 0 inheritance tax on that amount. What about the state level inheritance tax? There are only 5 states that impose a state inheritance tax, and only 2 of them will not waive it for the children. In the other states, the children or direct bloodlines get waived. Nebraska and Pennsylvania are the only 2 states where children have to pay a state inheritance tax. Fortunately, it's not, high like 40%. It's lower. So That's the state inheritance tax, the second death tax. Unless you live in Nebraska, Pennsylvania, you don't have to worry about it at all. The next tax is the capital gains tax. Anytime you make a profit, your house appreciated, your stock doubled, or your business grows, the government wants a piece of that profit. That's called the capital gains tax. Good news. The step up in cost basis rule says that when someone inherits an asset, its cost basis will reset to the market value at the date of death, reducing capital gains tax if it's later sold. So the key here is inherits. So if your parents sell their house and give it to you a day before they pass away, then they will have to pay a huge capital gains tax on the appreciation of the house. But if they inherit it to you and you sell the house one day after they pass away, you pay zero capital gains tax. So these are the three death taxes. Let's see how it actually plays out, okay? We have Mike here. He lives in Florida. His father left him quite a portfolio. $1.2 million, the primary home, an IRA and a Roth IRA, some stocks that he lucked on, and a life insurance policy, and a rental property. All in all, $4.5 million. Mike's first thought wasn't, whoa, I struck the lottery. His first thought was, I'm going to be hammered with taxes. Because that's $4.5 million. Will he? Let's check it out, okay? So let's start with the federal. This is his tax bill. Federal, the estate tax exemption is $15 million. This isn't even a third of it. So estate tax, zero. What about the inheritance tax? The federal has no inheritance tax, so it's zero. What about capital gains tax? Everything steps up. Even though the house appreciated tremendously, so did the rental property and his stocks, everything steps up to the market value when he inherits it from his dad. So capital gains, zero. Zero federal tax. Now let's go to the state level. Florida. As Florida has no estate tax, it wasn't in the list, so zero. Inheritance tax, again, zero. Capital gains tax, step up, zero. So the tax bill on this $4.5 million inheritance is a big zero. Now, if Mike lived in my state, Massachusetts, that has an estate tax exemption of only $2 million, if Mike's dad used his $2 million exemption, and if Mike's mother used also her $2 million exemption, that would add up the exemption to $4 million, then there would be an estate tax on the difference, $520,000. But the state level estate tax is not 40% like the federal. It's in Massachusetts, it only goes up to 16%. So even if this wasn't in Florida, even if we were in Massachusetts, the tax is not as scary as most people think. So this tax threat is a phantom threat. The real threat number 3 is inheritance erosion. What do I mean by this, okay? Suppose your estate, your legacy, dodged probate, okay? And it also dodged family fracture, okay? Nobody fought, they're still sharing Thanksgiving together. And you dodge taxes without too much effort. And finally, your estate made it to your heirs, whether it's your nieces, nephews, siblings, or your children. Well, a new set of risks show up. Let me go through these risks. Have you heard of the lottery winner's curse? A lot of lottery winners lose their winnings in a few years. That's what the data says. Some of them are even worse off. because too much money too quickly without guardrails just makes you do stupid things. That could also happen to our beneficiaries if we don't plan. The other side of the the spectrum is some beneficiaries feel so responsible for their inheritance that they put pressure on themselves to grow the inheritance. So they get into high-risk ventures and businesses that they know nothing about, and they end up losing their shirt. Are your children in high-risk professions like a surgeon, business owner, lawyers? Then their inheritance could also be subjected to the lawsuits and creditors that are very common for those professions. Potential divorce, this is big. Inheritance is normally considered a separate property, not a marital property, but it's so easy for it to get commingled after years and years of marriage. My friend, this is what happened to him. He took some of his inheritance to donate to a charity, not a lot, like a couple of $1,000 to donate to a charity. And he put his wife's name as a co-donor. Nice guy, right? Well, a few years later, when they divorced, the wife's attorney claimed that one act alone made the inheritance a marital property because he presented it as a joint donation. So half of it walked out with his ex-wife. Or if your heirs pass away before they have a chance to set up their own estate plan, then the court's default plan is that all their assets go to the next of kin, which could be your heir's spouse. And if that spouse remarries, essentially the inheritance has left the bloodline. So these are dangers to our heirs' inheritance that we normally don't think about. It's no wonder that this 20-year study of 3,200 families shows that by the second generation, only 30% of your estate is left. And by the third generation, it's 10%. So, when I said that this nice cake becomes just a slice or crumbs, I really wasn't exaggerating. This is what the data shows. So the three threats that we went over again is probate, family fracture, and inheritance erosion. From cake to crumbs. How does a living, well, before I talk about that, but I already kind of gave away the answer, but anyway, if there was one simple thing you could do to protect yourself from these three threats, would you do it? My guess is you would, right? That simple thing is the living trust. And now we're at the part of the agenda where I'm going to show you how a living trust is the answer to those threats. Okay? A living trust has to protect you against probate, keep the family whole, and preserve your children's inheritance. Let's start with the first one. How does a living trust protect you from probate? And it's really worthwhile to understand how a living trust does this, because you're not just because then it helps you understand when you need a living trust and when you don't. Let's step back with about this probate. I want to share with you the flip side of probate that no one talks about, the good intentions of probate. Now, you may say, like, what? Probate has such a bad reputation. You just told us all these bad things. Yes, that is true. But probate actually has good intentions, because when we die with assets still in our name, that's a big problem. We're no longer alive to transfer the titles of those assets to the rightful heirs or whoever we want to transfer those assets to. We're not able to do that anymore. So the courts have to step in. And the court steps in to protect my assets because I'm no longer around and the assets are still in my name. So the court will make sure that my assets are inventoried and assessed. The court wants to protect my wishes. If I have a will, the court wants to make sure that it is my authenticated will, that I didn't do it under pressure, or that it's a fraud. And the court wants to protect my heirs, that it wants to make sure that my assets will transfer to the rightful heirs. Okay. Unfortunately, how it actually plays out is often a nightmare, but the intentions of the probate court is to protect us. So when the way to avoid probate is to not still have assets in your name when you die. The way you can do that is by transferring the assets into your trust. So now you are no longer the owner of those assets. You're just a trustee. As the trustee, you are still the boss. You can live in the house. You can refinance the house. You can rent out the house. You can even sell the house if you want to. That's still all within your power as the trustee. But when we pass away, because the assets are not in our names anymore, there's nothing for the court to protect. So no probate. Which is why a will does not avoid probate, because a will is essentially a letter to the judge. The assets are still titled in my name. So the court has to oversee that title transfer. Okay, this letter to the judge is an analogy is this. Remember when you bought your house? When you bought your house, would it have been okay for you if the seller said, in exchange for all this money you're giving me, I'm going to give you a letter. I'm going to write a letter that says that you now own the house. Would that have been good enough? No way, right? You had your attorney with you. You made sure he had his attorney, and you made sure that the seller signed off. So the title is completely transferred to your name. A will is just a letter. So it's a ticket to probate. Now let's talk about how a will reduces family fracture. One, by avoiding probate, because probate is a big source of family fracture. It's a stage, ready-made stage for disputes. Secondly, the process of creating a living trust just makes you plan more intentionally. So you are more, you can think through the family dynamics and plan it out so that there are fewer surprises. Perhaps you even share your trusts with your children so that there are completely no surprises. So that's how a trust reduces family fracture. How does a trust protect the inheritance from eroding too quickly? One, when you use a will, it's a die and distribute. It means everything, all your assets, go to your children in one big lump sum as an outright gift, which means it's not protected from their creditors or from themselves. With a trust, you can stagger the distribution of the assets. So you can say, oh, I want a quarter. They should get a quarter when they turn age 30, and they get the rest when they turn age 35, 40, 45. You know your children the best. You set these ages. Until the beneficiaries reach those ages, they don't own the trust, which is a good thing. That means they cannot be sued. If they have a divorce, the ex-wife or ex-spouse cannot have access to it. If they're in a car accident, the other party's attorney can't go after the trust because they don't own it yet. You can't lose something you don't own. If I'm in a car accident, okay, and it's my fault, they can come after my house. Can they go after your house? No way, right? Your house is not mine to lose. That's the idea here with trust. Until they reach that age, they don't own the trust, so they cannot lose it. At the same time, even before they reach that age, they can access the trust funds for health, education, maintenance, and support. It's like the best of both worlds. The inheritance is protected, yet if they have a need that's health, education, maintenance, and support related, they can access these funds. Another layer of protection would be the trustee himself. If you trust your children or your nieces, nephews, you can make them the trustee of their own trust. But otherwise, you can assign another family member, maybe an uncle and aunt, to be the trustee, because the trustee is the one who interprets whether the need is health, education, maintenance, or support, and controls the distribution of the funds. By the way, this HAMS is called the HAMS standard. You'll come across it a lot in estate planning. It's a well-established standard that the IRS created, and the IRS basically allows beneficiaries to have access for these needs without losing protection, without saying that means they own the trust. So the trust still gets protection. So this is how a trust, you can see how with these safeguards, there is a higher likelihood of your inheritance staying intact longer, right? Gives the beneficiaries a chance to, get through the school of knocks a bit longer. Okay, so now we're moving into the 4 steps to create a living trust. All right, we've covered a lot of material here. You still with me? If some of this is moving too quickly, don't worry. I will be sending out a replay of the webinar. All right. So 4 steps to creating your living trust. Think of it as, because if it's your first time, it may feel overwhelming, creating a living trust, intimidating, but think of it as building a house, okay? The first step is your key decisions. Things you have to think through before you even hammer the first nail. For, is it going to be 2-bedroom, 4-bedroom, small kitchen, big kitchen, open layout, walls, that kind of thing. The second step is choosing your team to build the house, right? And the third step is getting the house inspected, approved, so that it's ready to be moved in. And the final step is to actually move into the house. You may be surprised how many people spend money and time creating living trusts, and then they don't put any assets into the trust. That's like spending money and time building a house and then not moving in to enjoy the protection and safety of the house. It happens too many times. Okay, now let's unpack each of this step. For a trust, what are key decisions? What kind of key decisions will you be thinking of when you're trying to create a trust? Well, if you're married, one of the things you want to think about is when the first spouse dies, does everything go to the surviving spouse? Or do you want the assets to be split up so the surviving spouse still has her half, but the deceased spouse, the spouse who passed away, his half is locked up in a separate trust? He can still take care of the surviving spouse with the interest income, but the principal amount of this trust is protected for his biological children. This is more common with blended families because if one spouse dies and everything goes to the second spouse could remarry, the surviving spouse could disinherit her stepchildren, or he could be exposed, the surviving spouse could be exposed to lawsuits and lose the inheritance. So I see this in blended families, or if there's a real liability risk of the surviving spouse, so that the deceased spouse wants his half protected. So these are some things you want to think about if you're married. If you have children or beneficiaries, you want to think about what ages they'll be ready to get their assets. Do you trust them to be the trustee of their own assets? It makes it a lot easier, more streamlined when they need funds for health, education, maintenance, and support, because they don't have to go knocking on an uncle's door or a professional trustee if they're their own trustee. But that depends how good they are managing money, how much you trust them. Then another decision to make is, would you allow your children to direct the trust assets to just anyone or to stay within the bloodline? A lot of families say, okay, if they don't need their trust funds, they can share it with their siblings or their children, but not their spouses. That way they're not susceptible to manipulative spouses. Because the trustee will say, I'm sorry, that's against the trust rules. It can only be redirected to the children or to the sibling. So these are just some things that every family will think of, through, because every family is different. And then finally, who are the people that you trust to step into your successor roles if you're incapacitated or if you pass away? So you want to think through about these things first before you step into a lawyer's office or sign up with an online planning platform. Okay, now step 2 is choosing your team, right? To build the house. For a trust, it's choosing your online platform. As you evaluate different estate planning online platforms out there, I want to give you a framework. There are 3 categories of online platforms out there. First is your general legal platforms. And these would be these general legal platforms are where people go to, for example, create apartment leases, business contracts, purchase and sale, and then they edit estate planning. I tend to stay away from these. I at least, would only entertain the second category. These are platforms that were created from the get-go as dedicated estate planning platforms. They don't do anything else. They don't do apartment leases, whatever. So their customer support, their entire infrastructure is geared towards estate planning. About 6, 7, 8 years ago, there arose a new category of online platforms that were created for advisors and their clients. These are invitation-only platforms, meaning you have to go through an advisor. And these platforms tend to be more sophisticated because clients who work with advisors tend to have more nuanced family dynamics or portfolio. So naturally, the platforms that were created, the platforms in this category, tend to be more sophisticated than the more mainstream DIY platforms. Okay, so when you evaluate platforms, at least get a framework which category they're in. Whichever platform you decide on, make sure they have these features. They have to be easy to use, but flexible and powerful, because your trust needs to protect you against those 3 threats, remember? And the documents have to be attorney drafted, not AI drafted or, someone piecing it together. They also need to be tailored to every state, because every state has different requirements. The support is huge. Since for most of us, this is our first time creating a trust, you want to make sure you have not just live chat and email, but phone support where you can pick up, and call someone. Audit checks, visual reports are also very important. And the security not to mention, has to be top notch because you're putting in confidential information. So this step, creating your plan documents, you want to look for platforms with these features. Here I show some screenshots from the wealth.com platform that I partner with. So it's question-based, so it's easier to navigate. For example, on this page, it says, what age do you want the descendants' trust to end? Meaning, what age do you want your descendants to receive their inheritance in full? So you could say a third at this age and the rest at this age. Or if you choose that they don't receive the inheritance until they pass away, you'd make this selection. So it's very easy to navigate question-based. You're just inputting your preferences. This review summary is very, very helpful because it puts all your key decisions on one page. The reason a lot of estate plans do not get reviewed, even though they should, is because nobody's looking forward to going through 30, 40 pages of legalese in their trusts. But if you have 1 or 2 pages of your key decisions, it's much easier to go through them on an annual basis to make sure nothing has changed. For example, when I did mine, I realized, oh, one of my successor trustee actually had moved abroad. So it triggered me to look for another trustee. A good plan also has a signature checklist of which documents need to be signed, witnessed, and notarized, which leads to the third step, getting your documents signed and finalized and notarized. When a DIY trust fails, a lot of times it's because it wasn't signed or notarized properly. It didn't meet the state's requirements. So it's very important that you stick with a signature checklist so you know, okay, for the trust, Sam needs to sign on this page, Mary needs to sign on this page, and it needs to be notarized, and so on. In fact, I tell my clients before they go to the notary's office to get these stickies and stick them on the different pages. So you're not at the notary's office flipping through 30, 40 pages of legalese. That will cause you to miss pages. With this, you can just calmly go from one tag to another. But I can't overemphasize this step, okay? You need to make sure your documents are signed, witnessed, and notarized according to your state's requirements. And a good platform will give you a checklist like this. The fourth step is funding the trust. It is transferring your assets into the trust so that when we die, we don't still have assets in our name, which will trigger probate. So that's the fourth step. This step cannot happen until your trust, your estate plan documents is completely signed, notarized. Because when it's completely finalized, number 6 here, when it's completely notarized, you will get a certification of trust. And this certification of trust is what the banks, the brokerage firms, your court, county clerk will demand to see when you transfer titles out of your name into the trust. They want to make sure that the trust is legit before you do that. Okay, so that's the fourth step. All right. Okay, let's summarize what we've gone through so far. We talked about the 3 threats: probate, family fracture, and inheritance erosion. We talked about how a trust protects you against probate by holding title, staggering inheritance, having a trustee, and also how it reduces family fracture by avoiding probate and also just making sure that things are intentional and no surprises. Next, we went through the 4 steps of creating a living trust. Okay, so that's what we've done so far today. Congratulations, that's a lot. My guess is that you now know about estate planning more than 90% of your friends. But here's the thing. I know you're not here to just get more information. So let's talk about how to implement this, how to actually get your living trust created. Traditionally, you have two options: do it yourself, or you can sign up an online course. With do it yourself, you're doing a lot of the research alone. You're weighing endless trade-offs. You're watching a lot of YouTubes, getting information. And after all that, you still feel a bit uncertain and confused because you're doing it yourself. Online courses promise to show you step by step how to get through it. But because there's no one-on-one support, when you actually apply it to your own personal, unique circumstance, you find that you need that one-on-one guidance for your specific situations. And when you don't have that, it's one of the reasons why online courses have a low completion rate. This is what the data shows. So that's DIY, doing it yourself, or an online course. Tonight, I want to present a third option to you, which is working with an estate plan partner. You will get your complete estate plan documents done in 3 one-on-one advisor meetings. How does this work? There are 3 components to the estate plan partner program. Okay. First is the wealth.com. That's the platform. That's the engine, the brain, which will be creating the legal documents. Next is one-on-one support with your certified estate planner, and the result is that you can get your complete estate plan. So that's the 3 components. Let's unpack each one. What does one-on-one support with a certified estate planner mean? It means you start with the one-on-one onboarding, and by the end of the onboarding meeting, you will have a draft of your revocable living trusts. Then we schedule a meeting to review the final documents after you have a chance to review it. So we like to give you time to review your documents, because the decisions you'll be making are, have big impact and consequences. So the onboarding, even though you could just rush through it and finish the document, it's much better if you stop at the draft stage and then you marinate and think about it, talk it over with your spouse, maybe even with your children before you finalize it. It's a little bit like Texas barbecue. I was just in Texas over Christmas, so the memory's still fresh. It doesn't take a long time to rub and marinate the meats, but to turn it into that legendary barbecue, you need to let it sit for hours. It's the same thing with creating a living trust. Believe it or not, going through the platform and answering the questions and inputting your preferences doesn't take a long time. It can be done under an hour. But what takes time is really thinking through those decisions. And then after the trust is finalized, we talk about trust funding. You'll have access to all the checklists, shortcuts, and resources that I've been collecting from working with several clients. All right, the wealth.com platform here. I am not a wealth.com employee. I'm an independent certified estate planner. So I could have chosen any online platform. The reason I chose wealth.com is because it has such a strong team behind it. Not just the legal team, but also the financial backing. So it's a powerful, robust platform, and it keeps improving. For example, it is able to create sub-trusts that normally attorneys would charge, special specialty fees for. What are sub-trusts? Sub-trusts are additional provisions you can create in your living trust that makes it even more powerful. For example, there is the marital sub-trust that that's for blended families. It protects the stepchildren from being disinherited. Then there's the dynasty subtrust for generational wealth building. There's the bypass trust if you your assets are getting close to the $15 million cutoff. When a lot of people start estate planning, they have only one goal, avoid probate. But as they learn more and more about estate planning, they realize that it is so powerful. Avoiding probate is just like your basic, it's like price of admission. It's like the real power of an estate plan is to create generational wealth. And in the past, that used to be just the realm of very wealthy people. But these powerful platforms that you have today can give you that capability. And wealth.com also has live chat, phone, email, Monday to Friday. So the program includes access to the wealth.com platform. It's not a separate fee or anything like that. All right. And the result is that you get a complete estate plan, which includes the revocable living trust, the pour-over will. You still need a will when you do a living trust, but it's not the same kind of will that is a standalone will. It's a pour-over will. And its sole purpose is to tell the judge, hey, if there's any assets I forgot to transfer into my trust, my intention is to have you pour it over into the trust. You will still end up in probate if you have assets that are not in the trust, but it will be a quicker probate because at least the judge knows that your intention is to pour it over into the trust. So the pour over will is like a safety net, but try to make sure that you will not have to use it. The healthcare proxy, who will be your spokesperson if you're incapacitated with regard to health matters. Your power of attorney, who will be your spokesperson if you're incapacitated with regards to financial matters. So these are the 4 core documents of an estate plan, and that's all part of the deliverable in this program. So the big difference with working with an estate plan partner, I feel, is that you're making real progress. Example, you get a draft of your living trust by the end of the one-on-one session. Whereas the DIY or online course, you're constantly consuming information and constantly learning about wills and trusts, but never quite making it to the finish line. Let's talk about costs, because cost is a big deal. When I ask, folks what's holding them back, why they have not gotten their estate plan done, it's not because they don't realize it's important. They absolutely know it's important. But many times it's the cost that holds them back. They research attorneys, they call attorneys, they even set up this free consults, and then they get the quote. And sticker shock hits them. And then suddenly it's like, oh, let's take care of this next year. So I understand cost is a real, concern. So let's talk about the options, okay? Probate. For sure, don't just do nothing, okay? Because if you end up in probate, that will cost you a lot of money. The other option is to go with attorneys, depending on where you live. For the full complete set of estate plan documents, it could be $3,000 to $5,000. And even if you do it yourself, it's not free, because do it yourself or courses will require you to sign up with a platform. If the course includes a free estate planning software, I would be very cautious. I would make sure it satisfies all the 6 features, because that's very suspect if a $250 course includes a software as well. So most do-it-yourself will require to sign up with LegalZoom, which is $500 for a couple, or trust and will, which is $600. And they give you 30 days of unlimited edit. So these are the cost options out there. Now, let me ask you, for a program where you're getting one-on-one support, you're getting a premium online platform, and a complete estate plan, based on what the other cost options are, what do you think is reasonable for such a program offering to cost? While I take a sip of water. Any volunteers? Well, I talk to my clients about their experience, and they tell me that when they see the high quality of the documents that they get with the wealth.com, and they experience the one-on-one support, and they see their own growth in estate planning, they feel that the investment of this program is worth even more than what an attorney charges. But I'm not charging anywhere close to that. The fee, the investment for going with our program for a couple is $795. And if you're not married, for a single plan, it's $695. And I made it even better with a $200 discount for webinar attendees if you take action by Monday, by the end of Monday. So why the deadline, right? If you've been following me on YouTube, you know that I'm very generous with my information, with my resources, ebooks, digital workbooks. So this seems uncharacteristic. Like why rush? Why rush people? Why put a deadline? Here's the honest answer. Why not? Why not take action today, this weekend, by Monday? Because after working with a lot of clients, I can guess that a lot of you have been spending a lot of time already going through YouTube videos, weighing options, trying to decide, which platform to go with. And tonight, you've invested yet another precious hour in this webinar. I know you're not here for more information, but that you want to, really just get this done. So this is providing you an incentive to take action. See, this is an email I received from one of my clients, and she said, thank you for lighting a fire under me. And let me see if I can make the other email show up. No. Okay. Let me just do this. Get rid of this, because I do want to show you this other email that I got from this client that I started working with in December. And in January, she sent me this email saying, my husband Ray passed away. And I held my breath because we had not had our final wrap-up meeting. But fortunately, she was able to get the will and trust signed, notarized, and funded before he passed away. That was, she was so close. So when I read emails like this, I do see it as part of my job to encourage you, to nudge you, because you are closer to the finish line than you believe yourself. So with the $200 off, the investment for a couple to get this program is $595, and for single it is $495. I'm also throwing in these 3 bonuses as further incentives. Free bonus number one is this booklet of estate plan checklist, because I get questions asked of me over and over again, what's the criteria for a successor trustee? What assets should be part of a trust and what assets should not be included in the trust? So I decided to just put all these checklists into an ebook. That's the first bonus. The second bonus is that unlike other platforms that gives you 30 days, you have lifetime unlimited edits. So 2 years down the road, if you have a new family member or if your, family situation, you got married or things like that, and you need to edit your trust, you simply get back on the platform. You simply sign back into the platform and make those changes. You will need to get them reprinted, signed, witnessed, and notarized. But that's a lot simpler than having to contact your attorney and paying, attorney fees for any little change you need down the road. That's bonus number 2. You have unlimited access, not just for 30 days, not just for 6 months, but as long as my partnership with wealth.com is still active. Bonus number 3 will blow you away. It is a complimentary wealth.com account that you can give to anyone, to your friend, your neighbor, any relative who still thinks a will is how you avoid probate, to your parents if they haven't created an estate plan. And they will get all the resources, the worksheets, scripts. They'll get bonus 1 and 2, which is the book of checklists and unlimited lifetime edits as well. The condition is that you will only get this bonus after you complete your plan, because I don't want you to get distracted. Okay, so those are the bonuses. When you sign up for the program at estateplanpartner.com, I just want to show you what to expect so you're not surprised. So when you sign up at estateplanpartner.com, you will get this web page and you will choose if you want a single plan or a couples plan. After you make your choice, you'll get to this payment page. Don't forget to enter the promo code, which is TRUST200, Oh, sorry, this is wrong. This is the 23rd. This was for my last webinar. Okay, so then you will enter your promo code so that the price will be reduced by $200. And after you make that payment, you will be in this appointment booking form where you will book your first one-on-one appointment with me. Okay, let's see. So here is the summary of the program. You are getting the one-on-one support, the wealth.com platform, unlimited edits, and the full estate plan. The bonuses are the checklist ebook, lifetime unlimited edits, and a wealth.com bonus account. Questions. So now we're open for questions. I covered a lot of material. Feel free to ask me questions about any part of it, anything I spoke earlier or about the program. You can just unmic yourself and ask your question aloud, or you can type in your question in the chat. All right.
Hi,
Hi.
my name is Tammy Chang, the same last name as yours.
Hi, Tammy.
I'm from California.
Oh, nice and warm. We're freezing over here in the Northeast.
Oh, okay. So my husband and I have talked to any state attorney in California, and it wasn't very clear to us how the marital trust, the subtrust will work, because we have community properties that are in real estate. Okay. And if my half, let's say if I died early, we're not blended family. We're husband and wife, 2 adult children. And if I died first, And if I want my portion of the marital I mean, community property to be directed to our children, so it's not subject to him possibly marrying another person after I die. I'm not
Mhm.
dying, I'm just saying in case I die first.
Well, it
Um,
goes both ways anyway. Goes
right,
both
right,
ways.
right.
Yeah.
So he was afraid that my half of the assets will be locked into some trust and that he can't access it. He can sell the homes or, you know what I'm saying, that kind of stuff. He will have to get permission from the trustee. I mean, I think he can be the trustee, right? Then he has full
Yes,
control.
yes, you can.
Right. So does that answer your question or?
Well, for a married couple, if you do a joint trust, the heirs don't get anything until both pass away. You just mentioned that you want the children to get your share after the first spouse death without waiting for the second spouse death. That already tells me you're going to need two individual trusts. A married couple can do a joint trust or individual trusts. So you're going to need an individual trust so that your share can be distributed to the children without waiting for the second spouse to
Wait. But the community property, I mean, you can really distribute my share of like the family home, for example. You can distribute that.
you can't cut it in half, but
Right.
the title can have other owners on it. So
I
right,
see.
yeah, it's a
Or
title.
is there a way to uh state in the trust that they won't get it until he passes away?
Some yeah, some couples in California, what they choose is that everything except for the house, that the other assets can go to the children immediately, but they don't want to, split the house. So in that case, you can be make sure you're joint owners with rights of survivorship. So when one spouse dies, then this other spouse automatically gets a house. It doesn't go through the trust, it doesn't go through probate as long as you make sure that the title says with rights of survivorship, because community property like California, that's not the default. You have to specify with rights of survivorship.
Wait, but with rights of survivorship, then that goes to the spouse. It doesn't go to the children, right?
Yeah. So the others, you can have it go to the children, but for the house, if you don't want it split, because what I heard you say is you want it to go to your husband first, then that's how, with rights of survivorship, we'll do that.
But then my part of my half the community property would not be protected for the children then.
No, it will not. If you want it protected, then you have to do two individual trusts.
Two individual trusts.
Can you know what? Can you set up a time with me? Can you email me to set up a time with me so we can go more in depth into this?
Sure.
I,
I really appreciate
I want
that,
to make
Mr.
sure
Chen.
I want to make sure to, if there are other questions I can answer too.
Okay, sorry, I didn't mean
Oh, no,
to
no, no.
hog the
I'm
time.
glad you asked because now people know that married couple can do a joint trust or a individual trust.
Okay. All right. Well, thank you very much, Ms. Chang.
No problem, Tammy. Any other questions? Is there any in the questions in the chat box that I can ask someone to read?
No, there doesn't seem to be any.
Okay. While we're waiting for questions to come up, I've done this webinar so many times that I have had people ask the same question over and over again. And one common question I get asked is, what assets belong in a trust and what don't? So the assets that belong in a trust are like your primary home, your business, your rental property, your farmland. So what's common is that all these assets have a title and they cannot be assigned designated beneficiaries. That's why they have to go in a trust. Whereas all these other assets below, there are some states that allow you to specify beneficiaries for a house. It's called a transfer on death deed, or in Florida, it's called a ladybird deed. So if your state allows you to specify a beneficiary for a house, then it doesn't have to go into a trust. A car, a lot of RMV makes it easy to transfer a car when the owner dies. Furniture doesn't have a title, so it doesn't belong in a trust, or a watch unless it's a very expensive piece of art, with papers and title. IRA, the I stands for individual, so that means it has to be owned by a person. You can't put it in a trust. Bank accounts, you can specify a beneficiary, brokerage accounts, life insurance. If you can specify designated beneficiaries, then they don't have to go into the trust. Having said that, some people assign the trust as the beneficiary, because if otherwise, then everything goes to the heirs immediately. So it's not protected. Excuse me. If you assign the trust as the beneficiary, then it goes into the trust. So that's one question that usually comes up. Are there other questions? You can just unmic or put it in the chat box. Let's see, what are the questions? Well, this other question I get asked a lot, is how to transfer a house into my trust. So you don't have to worry about this until your trust has been finalized, okay? If your trust is not finalized, you cannot take this step. But once your trust is finalized, you can transfer your house into a trust. You can either use professionals, such as real estate attorneys or title companies, usdeeds.com, to do the deed transfer of the house. You can also do it yourself if you are very organized and if the house title is very simple and clean. Wealth.com also has a service that will do it for you for $175 plus the recording fee. So these are just some options on how to transfer your house into the trust. It's very important that you do that. Otherwise, the trust would be for nothing. If we die with the house still in our name, our title, then it would still go to probate. All right. If we don't have any more questions, then I will just wrap up here, and I will email you the replay of the webinar.
Oh,
And
there is a question. Would you like
okay.
to answer that? Can you explain the grantor, trustee, and beneficiary? Some videos say you are all three.
Uh-huh. So the grantor is the person who created the trust. Okay, the grantor. And then the trustee is the person who manages the trust. And the beneficiary is the person who benefits from the trust. A situation where all these three is the same person is the revocable living trust. Because when we create the revocable living trust, we are the grantors. We create the revocable living trust. While we're still healthy and alive, we are the initial trustees. Okay? When we pass away or incapacitated, then the successor trustee steps in. But while we're healthy, we're the initial trustees. And the beneficiary of the revocable living trust while we're alive is us, is also me, which means I can sell the house, I can, refinance the house, I can rent the house out and collect the proceeds. So that's the case where all three roles is the same person. I'd like to wrap up here. Thank you so much for your participation. I hope you walk away with a lot more clarity about the threats and how a living trust encounters that and the 4 steps to creating a living trust.